First, I'm going to address your accusation that I have something against you, or so I haven't given you a fair shot, Ms. O'Neill.
It's all the time, Your Honor. It's all the time. It's disparaging remarks in the community. It's
hold on, stop, because you're not going to lie on me.
I'm not lying on you.
About you. I barely even know you.
Maybe you know
one
me.
campaign. No, I don't.
I've known you since law school,
Right.
Your Honor, and you know me.
I don't
since
know.
You went to the University of Kentucky.
What? You're this close from being held in contempt because I'm not about to argue with you.
Yeah. Okay. Go. Will you hand me my screen box?
Now go. I'm rushing a little bit because I understand one of my attorneys is in a hearing next door. And based on that, the judge has also stepped out to allow her time to come over and address her cases. So, O'Neill, is it one or two cases?
It's two. One's for me, one's for somebody else.
Yes, ma'am. That rubber man them together. That'd be too much like right. I'm going to first begin with the case of Eagle Finance Company versus Shamika O'Neill.
Good morning, Your Honor. Austin Howard on behalf of the plaintiff here on Zoom.
Thank you. Miss, can you officially put your name on the record, please, ma'am?
Mika Lynn O'Neill.
And Miss O'Neill, this is your motion on a garnishment challenge, correct?
Yes, it is.
And as an officer of the court, you understand I will not be swearing you in and that you're still under the obligation to give truthful testimony, okay?
Yes, I understand that obligation.
Thank you so much. All right. And that did review your motions, but if you could, is it, and a lot of it appears to be hardship, correct?
No, procedural concerns and lack of notice, as well as statutory limitations and exemptions apply, and then also medical hardship.
Mr. Howard, do you have an opportunity to review and respond?
Yes, ma'am. So, Your Honor, this is an agreed judgment. Ms. O'Neill signed off on this judgment. She was to pay an amount every month, and we wouldn't act on that judgment, wouldn't give a garnishment, this or that. She made her first couple payments and then missed a payment in October, and at that time, September. And in that time, with no payment in September, we then voided the payment plan and acted on the judgment that was entered and agreed upon. Reviewing Ms. O'Neill's motion here, I don't believe she's provided any exemptions that are applicable here to not have the garnishment be enforced. We honestly haven't gotten a garnishment payment yet either, so I don't know if it is going to be pulling anything or not, but at this time, it was an agreed judgment. She had an opportunity to review it. She signed off on it, failed to make a payment, and then that's when the garnishment was
May I
filed.
respond for the record?
Of course. I just wanted him to finish.
So I did not receive proper notice.
Proper notice of what, though?
Proper notice that it was
from
not
the complaint?
No, proper notice of the debt and the garnishment proceeding itself.
Before I just need to understand, that would be proper notice for the complaint with the debt.
Right. I didn't receive proper notice from them that anything was owed or due, period. I was making the payments. I got documentation that I got another documentation from them that I needed to make a different payment amount. The documentation that they sent, I paid that amount. I thought that it was paid off at that point. They didn't send me any collection bills. They didn't send me.
Can we get a time frame of what you're speaking of? Because I don't want to make any assumptions about the time frames. So you acknowledge that there was an agreed judgment entered into, correct?
Yes, and I was making payments.
Okay.
And
after that time, was there some other payoff amount or something?
Yes, that was sent to me.
When was that, ma'am?
I don't recall.
Okay.
I don't recall.
Do you have any of those documents?
I'm sure that I do, or I could come up with them, but it was simply a notice that they sent. It was like a payment amount letter, and it said, "Oh, okay, pay this amount." I assumed that once I paid that amount, it was paid off. Because they didn't send anything else. There was no, hey, you've got a judgment or you have something against you.
Okay.
They just garnished my wages or attempted to garnish my wages.
Okay. Mr. Howard also.
Yes, ma'am.
And I'm not done with my argument.
Well,
Just-
I'm trying to do it by pieces so
Okay.
I can keep organized with it, Miss O'Neill.
Okay.
Can you first tell me perhaps the document, the letter Miss O'Neill is speaking of?
Yes,
That
ma'am.
information.
Your Honor, once we entered into this agreed judgment, both parties signed off on it. I believe it was, she made her first payment in June, timely. In July, she was supposed to pay on the 6th of every month. I believe we had passed the 6th, and it looks like on the 15th of July, we sent a letter saying, hey, you missed your payment. Please make your payment soon or else, have to act on the judgment, essentially. That's the letter.
No, they
No,
never
no,
sent.
wait a minute. No, wait, please. So you sent out a July notice, you missed a payment, please make your payment or else we'll have to collect, correct?
Yes, ma'am, Your Honor.
Okay.
Do they have documentation of that? That
I-
it was sent and it was mailed to me
Well, you
because
also,
I did not receive it.
well, what letter are you talking about then? And what is your,
I'm talking about a payment letter. Look, first, let me just
first of
go.
all, I'm gonna tell you this, please calm down.
I'm gonna calm down. I'm not upset.
Okay.
What I am is I don't want to be in this court under these conditions. I don't think that based on our relationship, I'm getting a fair shot
I don't
or
even,
that I've ever gotten a fair shot. I know you're going to say differently. That's fine. So I want to put that on the record, number one. But number two, I didn't receive notice of anything I made a payment. I thought it was paid off. That was it. As far as my job, I'm on layoff. And so there is no income. So there is nothing to garnish.
first I'm gonna address your.
And I do have documentation of that.
First, I'm going to address your accusation that I have something against you, or so I haven't given you a fair shot, Ms. O'Neill.
It's all the time, Your Honor. It's
You-
all the time. It's disparaging remarks in the community. It's,
Hold on, stop, because you're not gonna lie on me. I
I'm
have
not
said
lying on
anything
you.
about you. I barely even know you. Maybe
You know
one
me.
campaign. No, I don't.
I've known you since law school, Your
Right.
Honor, and you know me.
I don't
Since you
know.
went to the
You
University
know
of
what?
Kentucky.
You're this close from being held in contempt because I'm not about to argue with you.
Right.
Only thing you've had before me is a small claims case not too long ago, which you won. Actually, it was going to be dismissed before you even made your arguments. I don't know what you're talking about.
Okay, Your
And you
Honor.
can lump me with other people who may have issues with you, but I don't.
Okay.
And I don't know where you get that from. And you're not coming in here unbiased and treating this court with respect or decorum. And I have definitely earned that. So don't, again, come in here with accusations or bias against me. I have not said anything negative about you. So not only have I been courteous to you because I understand you're in a hearing, despite I feel like you being rude when you came in here, I still moved your cases to the front of this docket.
I wasn't rude. I just was
That's your
trying to.
opinion. Okay.
Right.
And so you also don't have any documentation related to some letter and some payoff. Do you have anything showing what you paid when you got this letter?
I'm laid off.
Okay.
I
just
don't
can-
have that employment.
Can you just answer my quick question? Again, I'm
I
just
don't
trying-
remember.
Okay.
I'm laid off. I've been laid off since May of 2025. There's
Yes,
no
ma'am.
income for them to get.
Yes, ma'am.
Now, I mean, I guess that means that, we delay this. Once there's earnings, then they can garnish them.
Yes, ma'am.
Or I can simply pay this off. It was less than $1,000. This is ridiculous.
Well, this
I'm
is
not
just
going to
a
subject
process.
myself to embarrassment in this process when I'm laid off from my job
Ma'am,
and there's
I
no
understand
income to
that.
get.
There are other people who come in here. I'll have other garnishment challenges today.
Yeah, I'm
not
fine
here
with
to-
that, but there's no
I'm
income
not
for
in
them to
here-
get.
Okay. So all I can say at this time, looking at the case procedurally, that everything followed the proper procedure. There was a complaint. We had proof of service of the complaint. At one point, you entered into an agreed judgment with Eagle Finance Company and I'm not here to I'm not at all here to negatively judge why people fall out of the ability to keep up with their payment.
They didn't give me notice.
And then
I was paying them and they
your
didn't give me
your
notice.
argument is
I
that
thought
you
it was
did-
paid off.
Your argument is that you didn't get notice and it was paid off. Their argument is that they sent you a letter in July and then there's been no such payments. You don't have any proof
Didn't receive a
today.
letter in July.
Yes, ma'am. You don't have any proof of any payments that were made that I would consider, so I could say, is there need to be an adjustment? But only thing I can do at this time, because even in taking into account your hardship, is to ask that Mr. Howard and you continue to try to work something out. I cannot force parties to enter into new judgments, but agreed judgments or agreed payment plans, but perhaps that is something you can work out. But based on everything that you told me today, there is nothing, a legal valid basis to set aside or to stop the garnishment.
There's nothing to
Okay.
garnish.
So
I'm not even in that job.
but they'll still need their garnishment. They'll still are entitled to be able to seek garnishment once they find out who to garnish.
Okay, thank
And
you.
so, okay, I'm gonna finish again. So at this time, your motion to quash the
Is denied.
garnishment is just denied based on everything I just told you.
Thank you.
Okay,
Okay.
and that's gonna address that case, Ms. O'Neill. And you still have one more case? Excuse me, you still have one more case.
I've got to get back.
I already told, they know where you're at. Her partner's here. We know. You're making it longer than it needs to be. I still need to address the cases you have before the court. Next is Portfolio Recovery Associates versus Gina Williams.
William Rich for the plaintiff.
That was Will Rich. Okay, sorry. All right, and then again, Miss Miss O'Neill, I was gonna say your whole name, but Miss O'Neill, you are counsel for Gina Williams on this case?
Yes, I am.
All right, this is for your motion to dismiss. Would you like to make your oral arguments, please?
Judge, before we make arguments, could the plaintiff have some time to file a response? We just received this a few days ago. We've not had an opportunity to file a response. Could we file a response and we could either submit it on the record or if you want to put it back on the docket for a later date?
All right,
We filed a motion to dismiss because number one, we feel they lack standing. The complaint just attached a generic bill of sale and some type of assignment.
Yeah.
It doesn't identify Miss Williams or her account. And it's not enough under the law to move forward with this and establish that they're the real party in interest. And then our second,
okay, let me just give you, I actually did have an opportunity to review your motion, Ms. O'Neill. However, I will give them the opportunity to file a written response. My next question for you is, I'll give you a lot of times, again, motions to dismiss are heard, are taken under submission under review. Would you like a new court date, Ms. O'Neill, or do you want the documents, the motions to be submitted as is? Once I get a response, and then it'll give you opportunity to actually file a reply as well.
that's fine.
Would you like a new court date, or do you just want to wait for submission of all documents? Of all pleadings.
Whatever the court wants.
Okay. All right. Then
Message from you.
Sorry, Judge.
all right. So Mr. Rich, how
Yes.
much do you need to file your response, sir?
10 days will be fine, Judge.
All right. All right. And so that would put us at about the 26th, and then I'll allow you some time to have the response, at least any responses. Let's see. So 2/26.
I don't think I'm clear on what you're asking. I filed the motion to dismiss. He's filing a response to it.
Yes.
And you're putting a deadline for what?
If you so choose to file a reply, you can do so 10 days. It's like 10 days to file a reply.
That's fine.
Okay. All right. So that would put us, let's just say by February 6th. Okay. I mean, by February 6th. Okay. If you so choose, you don't need to, but it's if you so choose. And after that, it will stand submitted for, to the court for review based on, again, all the other motions for summary judgment. It'll just be within the discretion of the court as to when I can get to them based on all the filings of all motions for summary judgments, motions to dismiss and things like that. Okay.
Thank you.
All
You'll be
right.
excused.
You may. And then I'm actually going to relinquish my chair one more time. I'm going to relinquish my chair to one of my colleagues, Judge Jones, who has a case for, oh my God. You're welcome. So sit down.
All right, number 25C 27272, Saratoga Woods HOA versus Ron Heffler. Good morning, Mr. Snow.
Judge, how are you?
I'm doing all right.
First time we meet.
Yeah, nice to meet you.
I got your, all right, we'll go.
Yeah, go
I
ahead.
didn't mean to
Oh,
interrupt.
no, you're fine.
Okay. I'm perplexed.
All right. So the reason that we're here is because there were a few issues that I wanted to go over for explanations or clarifications, and I just thought it would be a lot.
Okay.
Writing back and forth. So first, so just procedurally, let's talk about it. I denied your motion for default judgment with the HOA requiring or requesting a legal instrument just showing that this defendant was obligated to pay the HOA. You've resubmitted, but when you resubmitted, the first thing I just wanted to discuss is you did not file like a default certificate.
Originally?
No, on the refile.
Okay, yeah, well, in the past, this is how it's done, and then recently, within the last 3 weeks or so, I was told that procedurally, I'm supposed to
Refile. Okay.
with a new default judgment,
Excellent.
okay? So,
Okay.
all right, so now that I know that if I do a renewed, I'm supposed to do another default judgment certificate. I didn't know that in the past.
Okay, well, that's fine. So the second thing I wanted to discuss was whenever you did refile, the new proof that you submitted was just a default judgment that was signed by Judge Moore last year, just showing that she signed it in the past, therefore, in essence, I should sign it. That's not what I'm looking for proof-wise. I need something showing that he is tied to this obligation. And really what another district court judge does is not, it's not evidence that would work in front of a jury. It's not going to be evidence that would work in the default setting.
He paid.
Okay, so that's my third point. So
24 case, he wrote me a check.
sure, and I saw that. So whenever you did refile that, okay, let's go back to the beginning.
All right.
The obligation you are seeking in this filing is for $3,263.86.
Yes.
All right, and if you go to it, you'll see that you submitted a document that itemizes all the fees that leads you to that obligation that you believe is owed to the HOA.
Yes, sir.
And that includes 9/1/22 through 6/5/25. So when you submitted to me that default judgment as the proof,
Okay.
yes, it's a big deal to me. It's
All
pretty
right.
big.
Well, this is what my client sent me.
Okay.
Okay, so forgetting that over a year ago that I had filed against this individual before, I just took the ledger sheet as shame on me
But if I would have signed off on this individual who's already paid $1,900.75 would be obligated to then again pay that same exact $1,900.75.
right
Or 1975. So that miffs me, okay?
Okay.
I know that you're frustrated by these rejections, but this is why we do it, because I do take this seriously. The last thing that I can do as a judge is put my name on something that obligates an individual to a debt they are not owed.
Right.
So
what I'll do is I'll admonish my client.
well, also, I mean, you are the attorney filing this, and this is why we do require certificates, because I mean, whenever you were putting your name to this, you were swearing that this is all true and accurate. And then here we are, and I almost signed off on $2,000 of an obligation that is not owed. Okay. So it's not just your client. It's also.
Okay. I understand.
All right. So the motion is denied. It can be refiled, but I just want to have this understanding on this is why we do this. I take these things. I know that they happen just in common core, but I mean, I cannot make it to where an individual is having to pay money that they're not.
Well, I agree with you 100%.
All right.
Okay.
All right. Thank you, Mr. Snow.
All right. Thank you, Judge.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what? We're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No patience for that. I'm trying to get out of the day. I'm the one that needs a drink.